members back. It's the first time that we're engaging since we closed off and headed towards the festive break last year. So it's good to hear your voices again. I'm sure see your faces shortly. I'd also like to welcome the officials from the Department of Economic Development and Tourism. In particular, we're joined by Mr. Ashley Searle, as well as the service provider. I recognize Ms. Priya Ramji from Moore SA Forensic Services, who have assisted us with the probity outcomes. I would also like to note the apology of Mr. Dube, who was unable to join us. But with that, I'd firstly like the members to have an opportunity to introduce themselves, followed by the department and then by the service provider.
Good morning, Chair. Good morning, colleagues. Andrikus van der Westhuizen, member of the committee.
Good morning, Chair, and good morning, colleagues also. I hope everybody had a good rest and Happy New Year to everybody. And yeah, thank you very much, Chair.
Good morning, Chair, and good morning to honorable members. Good morning to the officials. My name is Mbulelo Isaac Sileko, wishing you a blessed 2024. It is indeed going to be a great year. Thank you, Chair.
Thank you, members. I'll hand over to the department, starting with Mr. Searle to introduce themselves.
Good morning, Chair and members. Just switching on my camera that everybody can put a face to the name. So I'm Ashley Searle, Director within the Office of the Consumer Protector. And from my side and on behalf of the department, thank you to the committee for availing yourselves for this important process. And also I'm extending my prosperous greetings to all of you for the 2024 financial year that's upon us. Thank you very much. The next person from the department will be Mr. Buyile Noporte.
Good morning, Chair. Good morning to all the members and the other people from the service provider. My name is Buyile Noporte. I'm working for the department as a Deputy Director in Tribunal Support. I'm wishing you the best of the year. Thank you very much.
Thank you very much. Is the service provider with us? If you could please kindly introduce yourself.
Good morning, committee members. My name is Kevin Kearns, General Manager at Moore Forensics. Ms. Ramji has got a prior commitment, but she'll join us later. I'm joined by my colleagues, 4 of my colleagues who assisted with the due diligence. And they will probably introduce themselves. 5 of my colleagues, they will introduce themselves, starting with Patandwa.
Good morning, community. I'm Batandwa from Forensics. I am part of the DD team, one of the people that drafted the report.
Apologies, Ms. Mitya, there's quite an echo on your side. I'm not sure if you have another playback for this meeting.
Sorry. Okay, there's still an echo.
All right, welcome. You're welcome to sort that out in the meantime, and then we can come back to you if you like.
Good morning, committee members. My name is Shana Spanenberg, and I'm also from Moore.
Thank you.
Hello, Batando again. I hope there's no echo now. I am from Moore Forensics. Thank you.
Okay, perfect. So a warm welcome to everyone. Thank you for joining us today. Hoping that this is a very productive session. And we really appreciate all the hard work that has gone into this. Particularly, I'd like to acknowledge our procedural officer, Ms. Zahida Adams, who has been burning the candle at both ends to make sure that this rather complicated process goes as smoothly and as sweetly as possible. So a special thank you to Ms. Adams today as well. With that, I'd just like to touch on the rules of engagement for the virtual meeting. So as you'll all be aware, while we are in session, if participants could please mute themselves at the beginning of the meeting to avoid any background noises. We will, of course, point this out if there are any issues. If members have any issues they'd like to flag, such as points of order, they can do that in the chat function of Microsoft Teams. If you could please keep your video and audio off, just to help us improve the quality of the connection. But of course, when you're speaking or called on to speak, kindly unmute yourselves and your video. And then, of course, if you can switch off mics and videos once you have finished speaking as well. I'm sure you're very familiar with how to conduct these meetings, so I won't go into it any further than that, other than just to ask that we try and keep it as smooth and easy as possible today. So with that, we will move on to the briefing by the Department of Economic Development and Tourism on the interview and selection process for the Western Cape Consumer and Tribunals. This presentation portion can be open to the public as it doesn't contain any personal information about the candidates. From there, we'll move on to a question and answer session, and then to the briefing by Moore SA Forensic Services, where we will just need to briefly discuss whether or not we will have that in camera or not. But for now, it is open to the public, and I hand over to the department.
Thank you very much, Chair. For the presentation part, I'll leave my camera off. We struggle a bit with connection in the section of office space that we occupy here. I will be sharing my screen with the presentation. Please let me know once it's visible.
Oh, we can see it. It just needs to go into slideshow mode.
Thank you very much.
Perfect. Yeah, perfect.
Members, before I get into the presentation, just again, another word of thanks to all of you as well as the service provider. This has been at times a very demanding and challenging process. As you are aware, we started this process in the previous financial year and reached the stage where we were just about to schedule the interviews. And unfortunately, when we received the feedback from the probity reports, that scuppered the process for us. Unfortunately, the results of the probity in about 80% of the cases for the nominees wasn't positive. And then there was an engagement between our minister, the department, and the chair of this committee with regards to what do we do. And the best option was that we needed to start the process afresh. Because we needed to ensure that the tribunal members that we eventually appointed were of good character and had the necessary skills and expertise. So in this financial year, we've unfortunately started the process again. The results of the probity are much, much better this time around. And I'm looking forward to the conclusion of this process, hopefully on Thursday and Friday, and with a submission to the minister for possible appointment of tribunal members. And as I will get to certain sections in the slides, I will indicate exactly why this process is so important for us as an office, firstly, and secondly, the department, but most importantly, for the citizens of the Western Cape. And that's not only the ordinary citizens, but our business community as well. We firmly believe that the tribunal function will assist citizens and business as we move forward. Just in terms of the contents of my presentation, Chair, I thought it would be good just to give a little bit of introduction and background about the office. I'm not sure how much the members are aware, or even the public that might be dialing in, as to the services and functions of our office. So I'll start off a little bit with that. We will then deal with the legislative schemes that apply to us. I think it's also important to delve a little bit into what our office looks like. So we'll speak about the organogram. We'll then delve a little bit into the history of the tribunal, because in 2012 we did initiate this process and we had an appointed tribunal. But there were certain issues that arose in the latter years that impacted on the functioning of the tribunal. And there was a period of static where the tribunal was not functional. And I think it's important that we note that. And then we'll deal a little bit with the process that we followed, the adverts that we've placed and the results of those adverts, and exactly where we stand in terms of the nominees that we currently have available for interview. And then we'll speak a little bit about the next steps in the process. So first and foremost, I think it's very important to note that consumer protection is a matter that actually finds itself listed in the Constitution. So Schedule 4 of the Constitution lists consumer protection as a matter that has concurrent legislative competence between national and provincial government. And as members will know, that means that both spheres of government, national and provincial, have the authority to actually pass legislation on the issue of consumer protection. And that is currently what's prevalent in the country at the moment. We have, on a national sphere, we have the Consumer Protection Act of 2008, a piece of legislation that was introduced by national government to set norms and standards within the country with regards to consumer protection. I'll speak a little bit about that in the next slide. And then on the provincial level, we have the Western Cape Consumer Affairs Act of 2002. And this is primarily the piece of legislation that creates us as a consumer protection agency in the Western Cape. Excuse me. As mentioned, members, two spheres of government, both having legislation. So in terms of the Consumer Protection Act of 2008, it's a national regulatory framework. It obviously establishes national norms and standards. Within the Act, for example, we have specific provision that speak about the rights and obligations of consumers when it comes to transactional environments between the citizen and the business. So if, for example, one of the core provisions in the Consumer Protection Act is the introduction of a statutory warranty on products or services that you and I procure or purchase as ordinary consumers. So, for example, in the second-hand motor vehicle industry, which just happens to be one of the top areas of complaints that our office deals with, if a consumer purchases a second-hand vehicle, you automatically, in terms of the legislation, have a 6-month warranty on that particular vehicle. And in terms of that warranty, the service provider is obligated to ensure that the vehicle you purchase is, for lack of a better word, fit for purpose for a period of 6 months. And if anything happens during that first 6 months of purchase, there are certain specific rights that accrue to a citizen in terms of either requesting a repair of the vehicle, a replacement product, or in fact, in some instances, a refund for the purchase price. And the same applies to other services or products that us as consumers purchase or transact with businesses. Also importantly, the national legislation acknowledges the role that provinces perform, both as alternative dispute resolution agents within the consumer protection environment, but also importantly, the expanded role that provinces have to play in terms of enforcement of consumer protection rights. And when it comes to enforcement, the primary institution that plays that role would be the provincial tribunals, but also we have a national consumer tribunal that operates on a national level. The National Consumer Tribunal was originally established in terms of another piece of legislation, the National Credit Act, but they have a dual obligation in terms of functions, both in terms of the Credit Act, but also in terms of the Consumer Protection Act. The National Tribunal has been functioning for close on to 10 years and has over the course of time developed the legislation and developed the case law on consumer protection matters. So a very, very important institution, and one that the tribunal that we seek to establish will have very, very close ties with, especially in terms of developing case law and looking at precedents in terms of matters that have been adjudicated on a national level. The Consumer Protection Act also creates, I wouldn't like to use this phrase, but it is what we experience, a little bit of an unfunded mandate for us on a provincial level. And here I speak specifically on the issue of inspection of products that are imported into the country, especially clothing, textile, and leather goods. So there are specific provisions in the Consumer Protection Act which obligates an importer to comply with certain labeling requirements. And what we are now experiencing on a provincial level, because the National Consumer Commission doesn't have a provincial footprint, they rely on the provinces to assist them. So the implication for us is often, at least twice a month, we get a request from the National Consumer Commission to go and conduct an inspection at one of the import houses with regards to containers that have been detained by SARS for possible non-compliance with labeling requirements that are prescribed in the Consumer Protection Act. So that means that we've got to don our boots and hard hats and, you know, jump into containers and work through whether it's clothing or material that's been imported, carpets, shoes, and actually verify that the goods either comply or don't comply with the labeling requirements as prescribed in the Consumer Protection Act. So that's become a little bit of an added mandate to us, and we've had to juggle our resources around. And when I deal with the organogram, you can see that we are a very small institution, and that's placed a little bit of pressure on us. On a provincial level, we have the Western Cape Unfair Businesses Practices Act 10 of 2002. Primary provisions of this piece of legislation: it establishes our office as a consumer protection agency within this province. It also prescribes what our role and function is, two main roles, or three for that matter. On the one hand, we are established as an alternative dispute resolution process. So what that means is any matter that is lodged with us for investigation or inquiry by a consumer, the first phase that we go through is where we try and reach a negotiated and amicable settlement between the consumer and the affected business. And that plays itself out in arranging roundtable engagements, us doing an inquiry into the dispute, assessing the legislation against the complaint, and then bringing the parties together and trying to facilitate some sort of settlement without it going to the next step, which is obviously the adjudication function, which is delivered by the Consumer Tribunal. And as members would be able to note now, at the beginning I said that we did have the Consumer Tribunal operating for a very short space of time during 2012. Up until now, the tribunal has not been functioning. So our primary function as an office has been focusing on alternative dispute resolution. We've been very successful in this regard, but it's been like operating with one hand behind our back, because when matters are unable to be resolved amicably by us, we've unfortunately have had to refer those matters to the National Consumer Commission in the hope that those matters will be prosecuted at the National Consumer Tribunal. Some matters have, others haven't. So the importance of the tribunal for us is it strengthens our armory, and it allows us to perform our role to the extent of which the legislation obligates us to. So we're very excited to be able to eventually establish the tribunal again. And the process will then be after every matter, or not every matter, certain selected matters, which I, as the head of the office, will have to delve into if we feel that it's a matter that stands a success of decision at the tribunal, we will refer those matters to the tribunal for adjudication. One of the other areas which is also very important, both in the national legislation and the provincial legislation, is the issue of consumer education. So many of our citizens that we engage with on a daily basis, we find that many of them are either not aware of the existence of the Consumer Protection Act or the Western Cape legislation, or for that matter, the National Credit Act, and what rights and obligations it actually provides to citizens. So we do a lot of work in this regard. The team is often on the road, all areas within the Western Cape where we do information sessions, workshops, and other community outreach engagements. Recently, we've had a project where one of our key focus areas for this financial year will be financial literacy for citizens within the Western Cape. We feel that that's an important area of work that needs to be developed. So we will be going around to various communities and speaking on the issue of financial literacy. Why is it important to budget? How do you budget? If you're over indebted, what does that mean? How can the law assist you in that regards? What are the pitfalls that you need to be aware of? And if you are hounded, for example, by a debt collection agency, what are your rights in that regard? So we're doing quite a bit of work on that issue. Maybe something that I can also mention, members, we've got a specific project in conjunction with the National Youth Development Agency, where we run a program together with them at selected prisons. And the program focuses on inmates who are soon to be released, but have gone through a program within the prison where they've acquired certain skills. So whether that be carpentry skills, some plumbing skills, or electrician skills. And the hope is that if they are struggling to find a job in formal employment, that the skill that they've acquired during the incarceration will enable them to perhaps open their own business. And if they do open their own business, we coming in from the perspective of how do you manage your money if you're now suddenly faced with opening a business? What are the requirements that you need to comply with as a business when you start trading? Your responsibilities, especially towards consumers. I know today is not the opportunity for that, but perhaps at a later stage, we could provide the committee with some sort of indication about the exact projects and programs that we run. This is just the organogram of the office members. So I'm a director. I have 3 deputy directors, and we split into 3 areas. As I mentioned, the important issue of consumer education and marketing. We have a deputy director with 3 assistant directors and 1 admin officer. And this team is responsible for working throughout the province and spreading the gospel of consumer protection, not only to citizens, but we target businesses as well, especially SMMEs. We work with church groups, we work with NPOs, NGOs, schools, and other educational establishments. The next subdirectorate is our complaints management team. So this would be the team that deals with alternative dispute resolution. So this is, as I explained, where we get the parties together and we try and resolve the dispute between them. We only have 4 admin officers and 1 graduate intern in that area. Admin officers are on a level 8. None of them are legally qualified at this stage. Some of them are studying towards their LLB degrees, which will be beneficial for not only for them, but also for us. But that's just a relatively small team if one compares our structure to other provincial offices such as ours. And then the reason we're here today, the Tribunal Services Subdirectorate, as members can see there, we only have Mr. Napote in that unit, and his role will primarily be that of, for lack of a better word, the prosecutor of matters at the tribunal. In this current financial year, we did receive permission to fill an assistant director position, and that position would have been fulfilling the role of the registrar of the tribunal. But as members will be aware, due to the fiscal crunch, there was a freeze placed on the appointments of all positions or most positions. And unfortunately, that post was affected. So at this stage, we currently only have Mr. Naporte there. Once the tribunal operates, we'll obviously need to rejig our resources and shift some resources from the other areas to cover that area to ensure that the tribunal operates effectively, and that we commit will be done despite the challenge of resources there. I think it's important just to also mention that our work in the consumer protection space is not isolated. We've got to rely on a variety of different strategic partners, all of whom plays a specific role in the consumer protection environment. My office doesn't deal with each and every consumer protection dispute that can become active within the province. We have a ring-fenced jurisdiction, and if a matter is outside our scope of jurisdiction, obviously some of the other consumer protection agencies also play a role. Hence, these are just some of the partners that we work with. The National Consumer Commission that's been established in terms of the National Consumer Protection Act, the National Credit Regulator in terms of the Credit Act. So we work quite effectively with them, especially on the area of consumer education. The old Financial Services Board, now called the Financial Sector Conduct Authority. So if there's any disputes within that arena, financial regulatory matters, it falls outside of our scope and it falls within their scope. NERSA, predominantly in terms of consumer education, we work with them, and as you can see, the list goes on, including NGOs and NPOs, community structures, business and industry. We view all of them as important strategic partners in the area of consumer protection. So members, as I mentioned, we've got the Western Cape Consumer Affairs Act. I think I've covered this slide to an extent when we spoke about the provincial and national legislative scheme. But predominantly the Act provides for us to investigate unfair business practices in the Western Cape. Also allows us to provide those ADR services and also the adjudication services via the tribunal, and the important issue of consumer education and community outreach programs. As mentioned at the beginning, members, I think it's important just to give some insight into the history of the tribunal. So when I assumed my role in this office, I realized that the tribunal hadn't been operationalized, and that was one of the key areas that we worked on. And we first had to obtain permission to appoint the tribunal, which was done, and then we went through the entire process as we're going through it now. We worked with the committee of the day that was in existence in 2012. We then appointed the members that you see at the bottom. We had, I'm sure some people might recognize the name, Advocate Robbie Vincent. He was a stalwart in the Provincial Legal Services Department. He then retired, and he was appointed as the chairperson of the tribunal in 2012. We had another member, Advocate Mandla Mdudlu. He was also a legally qualified person. The committee of the day decided to appoint two legal people, because Advocate Mandla Mdudlu also qualified under industry expertise, and he was appointed as an ordinary member under that banner. We had Miss Jackie Lang. She was from the business fraternity, and Mr. Herman Wessels was an accountant. He was also appointed as a member of the tribunal. And then the committee also appointed two alternates. The legislation does provide for the appointment of alternate members. So Mr. Theo Barrows and Mr. Salbitin Dleni were appointed as alternate members. And that's a good a good initiative in terms of appointing alternates, because we wouldn't want to be in a situation where somebody on the tribunal unfortunately resigns, and then we've got to go through the whole process of advertising, probity checks, and interviews. So I would be requesting the committee to consider the appointment of an alternate for every member that is appointed, because that would just ensure that the tribunal is fully stocked with members in case an unfortunate incident happens and somebody needs to resign. So members, in 2016, the tribunal unfortunately was requested to cease operations. The department identified more pressing strategic imperatives. Resources were allocated from the unit to other areas. So we had Mr. Naporte, who was the prosecutor for the tribunal. As there was a pressing need in the department within the tourism space, he was then moved from my unit, and he became the tour guide registrar. Seeing that the tribunal was no longer functioning. So that led to a situation where from 2016 up until late December 2021, there was approval obtained by the then Minister of Economic Opportunities to then reinvigorate and re-establish the tribunal. And obviously, we then kicked off the process of finding new members in the 2022-2023 financial year. And as I've mentioned in the beginning of my introduction, that process unfortunately resulted in us not being able to finalize the appointments due to the outcomes from the probity reports. So as I'm saying, we're very excited and quite eager to get the tribunal operationalized and functioning, because this will be an adjudication body that will assist in enforcing the rights of consumer protection within the Western Cape province. And we'd also become on par with other provinces. Most of the other provinces have now also appointed their tribunals. There's one or two who are going through the same process that we are going through. But on the whole, there's a commitment from every province to ensure that the provincial tribunals are operational and that they can provide the final leg of adjudication services to both business and citizens. So just in a nutshell, somebody might ask, but what are the benefits of the tribunal? Why should we go through all of this hassle of appointing a tribunal and spend resources on a tribunal? The tribunal will provide finality to a dispute by way of an adjudication service. As I've indicated, we start off with alternative dispute resolution and selected matters that we feel should be prosecuted within the tribunal space. We will then forward for prosecution, and our office will play the role of prosecutor. We'll act on behalf of the consumer and advance a case at the tribunal with the intention of showing that there has been an unfair business practice committed by the affected business. Civil litigation, as we know, via the traditional courts are extremely costly and cumbersome, and most ordinary citizens can't afford such services. And in the legal space, there's very limited free legal services on civil-related matters, and a tribunal provides that alternative option for citizens to come and obtain relief with regards to a dispute in the structure as a tribunal. There is also a benefit for businesses, especially SMMEs. When we engage with SMMEs, they often say to us that, consumer disputes is an area of concern for them. Often many SMMEs are small enterprises where there's, no big back office with a dispute resolution team and a legal team. It's often just the business owner and a few other individuals in the business, and they get wrapped up in disputes. That takes them away from the core function of the business. Often they've got to spend exorbitant amounts on the services of attorneys to help them with these disputes. So with the tribunal being there as another forum through which disputes can be channeled, obviously it's a free service. The business is free to decide if they would want to have legal support during these disputes at the tribunal. But if they decide that they'd like to advance their cases on their own and save costs in that way, that is obviously a huge benefit to them. And we're hoping that the service of the tribunal will be less complicated, will be less time consuming than ordinary courts. So matters will hopefully be resolved in a shorter space of time, and then enabling both the consumer and the business to actually get back to to their ordinary lives. They don't want to be wrapped up in disputes all of the time. So the tribunal will play an important role in that regard. Members, I'm now moving over to the provisions in the Consumer Affairs Act that speaks specifically about the Consumer Affairs Tribunal. That would be sections 14, 15, and 16 predominantly. So in terms of section 14, the responsible minister must establish one or more consumer affairs tribunals for the province by notice in the Provincial Gazette. And the legislation also provides for the possibility of establishing more than one tribunal in more than one area. But for our purposes, we've decided that we will only have one tribunal operating within the Cape Town area, on the understanding that if we have disputes, let's say, for example, in the Garden Route area, that we will not necessarily be expecting the parties to travel to Cape Town. Depending on the specifics of a particular matter, it might be easier for the tribunal to actually provide the dispute resolution service in the Garden Route area. Many of the other tribunals operate in the same space. For example, the Rental Housing Tribunal works exactly on the same basis, and they make use of offices in the George area from the Department of Local Government, and there's a specific hearing room in George where the Rental Housing Tribunal will sit and adjudicate those matters. And we've seen a similar opportunity here. In 2012, we operated on the same basis, that when there was a particular matter that needed to be adjudicated in a different area, we were open to consider having the hearing in those areas. But for this purpose, one tribunal to be established, not more, not different tribunals in different areas. It will solely be one tribunal with the possibility of being a roving tribunal across the Western Cape. So section 15 specifies who must be appointed to the tribunal, and this is very important. So members must be appointed by the responsible minister in concurrence with your committee, and a tribunal must consist of 4 persons, namely a chairperson who must be either a retired judge of the High Court or an attorney, advocate, retired magistrate, or lecturer in law at the university with not less than 10 years cumulative experience. In addition to the chairperson who must have legal expertise, we also need to appoint 3 additional members. And these members must have specialist knowledge or experience of consumer advocacy, economics, industry, or commerce. And as I indicated with the history of the tribunal previously, the 3 additional members that we appointed in 2012, one had business experience, so that was the industry experience. The other had commerce experience, which was the accountant who worked for a big firm. And then we had a representative from the community who was a consumer advocate, very active within the Western Cape. And he brought a completely different set of skills to the tribunal. So we're hoping with the vast mix that we have of nominees this time around, that we can find 4 members for the main part, 1 legal expert, and the rest occupying the space with expertise in those specific areas that we've indicated there. And as I've also indicated previously, we will be motivating for the committee to consider appointing an alternate for each member that is appointed to the committee. And as I've said, Section 53 then gives that ability to the minister to appoint the alternate member. The committee can make a recommendation to the minister in that regard. Just in terms of the process of how all of this unfolded, how did we get to the nominations? How did people become aware of it? The legislation obligates us to place an advertisement in print media and in the Provincial Gazette, calling from nominations from the public, and we have to at least provide 21 days for the public to provide this nomination. So that's what we followed. Later on in the slides, I'll give you an indication of where we published in. Due to cost issues, print media is quite expensive. We would have liked to have gone a little bit more expensively in terms of, the media houses that we use, the print media houses. But we had to be realistic in terms of the budget that we had. So we printed in, I think it's a total of 16 publications across the province. But what we also did, my office went on a mini roadshow, and we went to different areas across the Western Cape in conjunction with the Department of Local Government, and specifically the Community Development Worker Program. We engaged with citizens and business on the process that was unfolding, and we encouraged people to nominate citizens for membership to the tribunal. We also obtained some free space on especially community radio, where we were able to then engage with citizens via radio, and also spoke to them about the nomination process. And I think it's been successful. If one looks at the total number of nominees that we received in the process that had to be halted in the previous financial year, we only received 11 nominees. This time around, we've doubled that. We received 22 nominations. And from that, yes, there's been a few that have withdrawn their nominations, but I think we're still left with a really good mix of nominees that can be considered for appointment to the tribunal. So I think we've been relatively successful in terms of securing nominations from the public for this process. Just in terms also of the process, members, so once we received the nominations from the public, we also had to print those names of the nominees in the print media, and call for any comments that citizens had with regards to a nominee. Again, here we had to also look at the budget, and we only focused on 3 major print media sources. That advertisement was printed, and unfortunately, fortunately, we've received no comment on any of the nominees. And as a safeguard, to the comment on nominees, we've also gone through the probity exercise. So I think you need to consider the publication of the names for comment, and the fact that we've engaged in a probity exercise. I think we're pretty secure in our minds that we've done a really good background check and vetting process for the nominees that we have. And on the whole, my colleagues from the service provider will go through the results of the probity exercise. But on the whole, I think we've received positive feedback from most of the candidates. If my memory serves me right, I think there's probably 2 candidates that were not recommended, but in the closed session, the service provider will go into the details for that recommendation. As members are aware, the interviews with nominees are open to the public, and Section 7 provides that the interviews must be conducted either by the minister or by an official of the department duly appointed, as well as your committee. And members will or should be aware that the provincial minister decided to delegate her responsible on the selection committee to myself as head of the office. So I will be joining members on Thursday and Friday as a member of the committee to select prospective members to the Consumer Tribunal. Also importantly, before any of the members take office, they make or subscribe an oath or a solemn affirmation in the prescribed form before the responsible minister. So once the minister receives the committee's recommendation and applies a mind to it, and then decides on who the appointed tribunal member should be, the final step in the process would be for us to convene an engagement with those selected nominees, where they will take an oath or a solemn affirmation before the responsible minister. And there is a prescribed form that was developed in the regulations that accompanies the Western Cape Consumer Affairs Act. Importantly, in terms of excuse me, in terms of remuneration, yes, the tribunal members will not be performing this function for free. We will be obligated to pay them a remuneration, and this will be determined by the minister in conjunction with the Minister of Finance within the province. And as we know, Minister Wenger performs both roles. So she would have to consult in both capacities and decide on what the remuneration rate for the members would be. The standing practice across all provinces is that we utilize the remuneration tariff that has been set by National Treasury. So National Treasury every year publishes a tariff for statutory board members or members of tribunals, and there are various categories of remuneration that are prescribed. So we will be utilizing or recommending to the minister that we will utilize that tariff. It will be a daily tariff to which members will be remunerated accordingly. And as I said, this is something that has been adopted nationally by all provincial tribunals in terms of the remuneration scheme. The Act also prescribes what members should be disqualified from becoming a member of a tribunal, and the list is there, members. I'll just run through it. So somebody who's not a South African citizen, somebody who is a public servant cannot serve as a tribunal member. At the time is or during the preceding 12 months was an office bearer or employee of any party, movement, organization, or body of a party political nature, an unrehabilitated insolvent, somebody convicted of theft, fraud, forgery, and anybody that's been removed from office on account of there being some sort of misconduct in their past. Act also provides that somebody who's absent from 2 or more consecutive meetings of the tribunal without leave of the chairperson would also be disqualified from being continue to perform the role as a member of the tribunal. Member section 17 just delves into a little bit of the finer details with regards to the process of the tribunal. So any decision of the majority of the tribunal members would be a decision of the tribunal, so it doesn't need to be consensus. It's a vote of majority, and that would be the decision of the tribunal. And as you can see, there are certain other obligations on tribunal members. Obviously, one of the important issues is conflict of interest, and the Act provides that if there are any issues in which a tribunal member might have an interest or some sort of conflict, they are obligated to raise that and recuse themselves from the proceedings. A pretty standard provision. We would expect that from a governance perspective that this would be almost par for the course with regards to any functioning establishment that performs a legal mandate. And importantly, members, the powers and functions of the tribunal. So to put it in a nutshell, the tribunal will perform a quasi-judicial function. So in other words, they will think of them as sitting as a court, a consumer court, but not a civil court. They will be responsible for hearing evidence, evaluating evidence, and then deciding that based on the evidence that has been submitted to them, they need to decide whether there was an unfair business practice that has been committed. And the Act speaks about what an unfair business practice could entail. This could, for example, mean that if there was any unfairness in a transaction that occurred between a consumer and a business, this could fall within the domain of an unfair business practice. And also, if there was certain advertising, we often see this coming up where consumers are aggrieved with responding to an advert that was placed only to realize that once they venture into the business, what was advertised is actually far from what was on offer at the business. So that might also be considered to be an unfair business practice. And the tribunal will be empowered to adjudicate on those matters and determine what recourse could be provided to a citizen. Members, I also want to note that the provincial tribunal will also, in certain instances, be mandated to hear matters that have been referred to them by the National Consumer Commission. So the National Consumer Commission is my office, but on a national level. So the Consumer Protection Act does contain a provision, it's section 73(2), where it says that if the consumer and the business is residing in the Western Cape and the Commission feels that the Provincial Tribunal would be best placed to deal with the matter, the Commission can in fact refer that matter to the Western Cape Tribunal. And if that is done, the Western Cape Tribunal in fact acquires the same powers and functions that the National Consumer Tribunal has on a national level. And they could make any decision that the National Consumer Tribunal would make in that instance. And this explains also the reason why on a national level, the National Consumer Commission has been very eager to ensure that the Western Cape Tribunal is up and running, because there are matters that have a uniquely Western Cape flavor that resides currently with the National Consumer Commission, which they actually want to refer to the province's tribunal for adjudication. And obviously at this stage, with the tribunal not being functioning, that's been a bit of an impediment. So we're looking forward to, once the tribunal is operational, we will certainly see some matters being referred to us in terms of the provision that I've just mentioned, that will be referred to the provincial consumer tribunal, and they would then have to adjudicate those matters. So again, I think it's another intervention that's just going to strengthen and enhance the role of our office within the Western Cape. Just again, in terms of the process, I've spoken a little bit previously. So we've placed the nomination ad in all 3 languages. We've used 16 newspapers, including the Provincial Gazette. The Gazette notice was published during July 2023. July 2023, as well as in the general newspapers in 2023. We exceeded the 21-day submission period because we actually extended the closing date for nominations. The closing date was extended to the 31st of August 2023. So citizens had more than a month within which to submit their nominations. And we've seen, as I've said, almost a doubling of the nominations if compared to the previous process that we followed. So we initially sat with 22 nominees that came through via the public advertisement process. This is just a snapshot of the publications that we've used. So the three big ones circulating within the province: Cape Times, Cape Argus, and the Burger. And then we, due to budgetary issues, we had to select certain other newspapers, and you can see there, we've tried to cover as many areas as possible. And as I've said previously, in addition to the adverts, we also went on a communication campaign, a public outreach campaign, where we engaged both interactively with citizens, but also via radio broadcasts, alerting citizens about the nomination process. To give you an indication, members, those selected newspapers that we utilized, the advertising costs for just for this particular notice was about 250,000 Rand. So you can imagine if we had to extend it, say, to another 10 newspapers, we would have exceeded our budget. We had a budget of 400,000 Rand for this year, which was to be used for the publications, but also the probity exercise that we've had to undertake. So we would definitely have exceeded the budget if we had to go to more newspaper sources than the ones that we actually utilized. The results of the call for public nominations, as I mentioned, 22 nominations that were received from the public. The table you see below is the nominations from the public for persons with legal expertise. We see the diverse list that we have here, predominantly a mix between advocates and attorneys, some with really good experience, specifically in consumer protection. And once we get to the results of the probity, I'm sure that the service provider will go a little bit into the specifics of each person. Not to, please, it's not to give a preference. I'm just noting this as a good mix of nominations. Besides the advocates and attorneys, you will notice that nominee number 7 is Professor Chaki Nodia. She is a professor at UCT, specializing in consumer protection law, and has been a contributor to one of the books on consumer protection that is almost a staple for all of us that we refer to and that we utilize. So a really good nomination there, and somebody that's not necessarily an admitted advocate or attorney, but providing a different skill set in terms of academic experience within the legal environment, but a really, really good and strong set of nominees within the legal expertise area. These are the other members, the non-legal expertise. So these are the individuals with experience in commerce, industry, consumer advocacy, etc. Also a really good list of individuals. We even have somebody who was well known. I don't think she performs that function anymore. She used to write a consumer column quite regularly, and my office would receive many queries from her with regards to specific issues that we were dealing with. And then we also have an array of other nominees with expertise in business, and also expertise in consumer protection advocacy issues. I note one particular individual who works for a non-profit organization which plays a big part with providing citizens in a specific community with access to justice on issues including consumer protection matters. So again, a really good mix of individuals, strong individuals, all possible nominees, strong nominees for appointment to the tribunal. As mentioned, we had to place a call for comment on the nominees. We only used the 3 big newspapers again due to budgetary issues, and we received 0 responses from members of the public. But as noted, in addition to the publication, we also did the probity exercise as part of the vetting of each individual member. Subsequent to us receiving the nominations and then embarking on the vetting process, we had 5 nominees withdraw. The reasons for withdrawal were varied. Ability to set aside time for work on the tribunal, business interests that were pressing. Those were some of the responses that we received from these nominees, so they withdrawn from the process. Dr. Neville Kluti, he was within the legal expertise area. Ms. Kay Rosina Dalport, also legal expert. She's a practicing attorney in the Western Cape. She unfortunately withdrew. Mr. Chuma Fani, he was nominated in the ordinary member category. Mr. Faiz Ishmael was owner of a small business. He withdrew, as well as Mr. Grant Jansen. So 5 out of the original list of people that withdrew from the process. So after the withdrawals from the nominees, these are currently the nominees that we have available to be interviewed members. And obviously, we'd have to consider this list in conjunction with the result of the probity exercise, and then decide if all of them will be interviewed or if some of them will be interviewed. But currently, these are the nominees that are available to be interviewed. So we have 9 within the legal fraternity that are available for interview. 1 or 2 initially indicated challenges with the dates for the interviews, but we've subsequently, in conjunction with the procedural officer, and thank you very much to her, she's done a sterling job. We're able to ensure that some of them that weren't able to attend will now be able to do a virtual interview. So we've got 9 within the legal expertise area that's available to be interviewed. The ordinary nominees, as I said, we've had a few withdraw, but these are the members that are available for us to interview. And once we obtain the probity report, we will then make a decision on who specifically will be interviewed for the process in the tribunal process. Members, this is my last slide. I see I'm nearly close to an hour. My last slide. Obviously, the remaining step is now for us to have the interviews with the identified members. And after the interview process is concluded, the selection committee will then make a recommendation to the minister. The minister will apply a mind and then decide on which members she wishes to appoint to the tribunal. And once they've taken the oath or the solemn affirmation, they will be formally appointed as tribunal members. And from our side as a department, the first thing that we will do is convene a training session for the members, both in terms of what the legislation provides, but also in terms of the process that must be followed by the tribunal. And we have, in fact, for this financial year, we've acknowledged that by the time that they would be appointed and the end of the financial year, there might not be enough time for them to have considered formal matters, because before it lands at the tribunal, there's an entire process that needs to unfold, a procedural and administrative process. But the Act also allows the tribunal to confirm settlement agreements that we as an office have negotiated via the ADR process. So what we intend to do in the month of March is for the tribunal to sit and consider a number of settlement agreements that we've managed to negotiate between the consumer and the business. And the tribunal will be empowered to confirm that settlement agreement, which gives it standing and which makes it difficult for the business to extricate from that settlement agreement. And it gives finality to both parties in terms of the agreement that's been reached between them. But from the new financial year, we are hoping that from May onwards, the tribunal will start adjudicating disputed matters that would be advanced by the office. And so we've firmly identified some matters that we would like to take to the tribunal, and we're also engaging with the National Consumer Commission, because there might be one or two matters that they'd want to refer to the Provincial Commission, to the Provincial Tribunal as well. So members, I hope I've been able to summarize in a nutshell what it is that we do, and also what process we followed in terms of securing the nominations, and what are the remaining steps in terms of appointing the members to the tribunal. Chair, I'm going to end at this stage. Thank you very much for listening to me. Thank you, members.
Thank you very much, Mr. Sil. We really appreciate the comprehensive provide back that you've given us. Members, with that, I would just like to give you an opportunity to ask any questions of clarity. If I can ask that we keep the questions in rounds of 3, and then we can come back for further questions. Please raise your hand if you have any questions. I see Member van der Westhuizen.
Yes, thank you, Chair, and also from my side, big thank you to Mr. Sil. Chair, I've got a number of questions. The first one is, do we have an indication of the expected demands that will be put on the members of the tribunal time? And have the members been informed of the intended remuneration? If I understood Mr. Sil correctly, that still needs to be determined. And Chair, the reason for these two questions are that I'm concerned that we may go through an interview process, an appointment process, and then unfortunately see that a number of these members then have to withdraw once they hear that, for example, the demands will be much higher than what they initially made themselves available for, or what they had in mind, or alternatively, where they might believe or find that the remuneration does not match their expectations. Then the third question is, will there be a budget available for the tribunal, including training? You indicated that you yourself will be providing some training, but then what I've seen with other tribunals and other entities is that people want to travel to other provinces to go and compare notes in order to just better acquaint themselves with the challenges and experiences of other experienced tribunals. And also in the same vein, as far as budget is concerned, it is my impression that a well-functioning tribunal will require a lot of administrative support, perhaps more than what one individual would be able to provide. Is my fear founded that administrative support might exceed that which only one person would be able to provide? And if so, how are we going to overcome that? Thank you, Chair.
Thank you very much. I recognize Member Nkondlo.
Thank you, Chairperson. Are you able to hear me?
Perfectly.
Compliments of the season to you, Chairperson, members of the committee, and the team from the Consumer Protection Services. The first question I have, if Mr. Sil can just repeat because he said when he took office, the tribunal was not operational. I just want to understand how long is this period where the tribunal has not been years.
Sorry, Member Nkontlo, I'm not sure if it's just me, but it seems to be breaking up quite a bit. So if I could maybe suggest,
what mechanisms have been used to deal with investigations, consumer investigations that have required a tribunal?
Okay, Member Kotla, I'm going to mute you and I'm going to WhatsApp you and ask if you can please send your messages in the chat function. It's very, very, very difficult to hear you. Okay, members, are there any further questions? I see there's a follow-up from Member van der Westhuizen. Okay, he said no, that he was struggling. All right. Member Nkontlo, if you can hear us, please send your questions through in the chat function. Ms. Adams, if I could kindly ask you to just WhatsApp Member Nkontlo and make that request. I'm going to put a few questions of my own forward just for this round. My first is, I just wanted to get a very clear understanding on what the difference in the function of the tribunal is and what the board would be. Is there a board that will be have any kind of oversight in this with regards to consumer protection in the Western Cape? Then my next question is with regards to the candidates, so the 4 ordinary members and the 2 additional members, what sort of qualities are we looking for exactly to make sure that this is a robust and an effective tribunal? I know there's a lot of emphasis on sort of legal expertise. And then just regards to the ranking of the candidates, whether there is a process for the ranking of the candidates that would be ideal in order to convey this. So for example, in what order do we rank them? How many do we rank for a position? If I place one person in number 1 and another person in number 4, does that mean that 1 is better? Or does that just mean that 1, like 4, is a part of the board? So if we could get some clarity on those questions, and then we can come back for a second round. Over to you, Mr. Saul.
Thank you, Chair. I'll deal with them as they've come through. So, Mr. van der Westhuizen, the demands of the tribunal. So for the first financial year, we anticipating that they will be operational from next financial year because we're already in February. So we are anticipating 2 hearings a month for the tribunal, at least in the first year. So we are not envisaging that the tribunal is going to suddenly be thrown with matters that are going to be keeping them busy for 3 sessions every week. And we've done that quite consciously because we will have to identify firstly the matters that will have to be prosecuted. We've got a few matters that we've identified. And we are also, some of the matters that we would have sent to the tribunal are actually already pending at the National Consumer Tribunal. So that process needs to unfold. So we won't be recalling those matters. We will let those matters be concluding at the National Consumer Tribunal space, and we will be identifying the matters in the provincial space that we will be prosecuting in our area. So the demands I'm not seeing to be in the first 6-7 months to overwhelm the tribunal members, because we also understand that this is going to have to be a period of adjustment for them to get into the swing of things. In my previous experience before I came back to the department, I worked for the Community Schemes Ombud Service as an adjudicator, and despite my vast legal and administrative experience, it took me about 3 to 4 months to get to grips with the legislation, the processes, and actually the administrative undertakings of adjudicating matters. So I don't think for the first year that the demands are going to be very, very hectic. Obviously, for the years that follow, the intention is for us to push up the pace quite drastically, and we're hoping that when we push up the pace, it's going to be accompanied with a bigger budget envelope, because you have raised the issue of budget, and I agree with you. It's a very important issue for us. That's why in the beginning I said that the training initially will be done by us. We do have a budget for next year for the tribunal. It's not a very huge budget. It's sufficient to cover the remuneration of them based on the target number of matters that we've identified. But also in terms of training, we've engaged with the National Consumer Commission as well as the National Consumer Tribunal to also provide training to our members. The advance of technology now with virtual training be provided, that will reduce the cost quite dramatically. And those two entities will not be charging us for training of members. But yes, the budget is an issue that we would need to consider very carefully. We've advanced the budget from the department. We've requested one, but with the severe fiscal constraints that we're all facing, our initial ask wasn't given at the rate that we've asked for, so we've got to make things work. And one of the things that we've identified now is looking at our stakeholders, as I've mentioned, the National Consumer Tribunal and the National Consumer Commission, to assist in terms of training and therefore assisting with a limited budget that we have. The remuneration of the members, yes, it is a real concern. We've seen in other spaces where that has affected the appointments of potential members. We haven't provided the exact remuneration framework to the members or to the nominees, but in the advert that we placed, we did make note of the fact that they will be remunerated according to the Provincial Treasury tariff, but we haven't provided that to them, member. Perhaps it's something that we could consider to include on Thursday and Friday when we interview some of the members. But speaking to when we went on a campaign, many of the interested parties, and I'm not sure if they are the eventual nominees, but lots of people we spoke to also mentioned that this is such an important issue for them that remuneration is kind of secondary, but that doesn't apply to everybody. Doesn't mean that everybody will be satisfied with what the remuneration is going to be. So yes, I think that is a valid concern that you've raised. The administrative support, yes, currently, as I've indicated, it's only Mr. Naporti, but we will have to rejig our resources within my space, but also within the department space. We've had a discussion to see how we can rejig resources and provide support to other units, including mine, where that support is needed. As I've indicated, there's an assistant director post that we're hoping is going to be released and that we could fill. And we will also be looking at graduate interns within the legal environment to also assist us with administrative support. We're going through a process now where the department is identifying graduate intern needs, and we've put up our hand and said that for the tribunal support area, we definitely need some support in that area, and we're hoping that the graduate legal intern will provide some assistance. But in addition to that, rejigging the resources within our space to make sure that we'd be able to sufficiently resource the admin area for the tribunal, because we can't let this fail. It's very important to us. Member Nkondlo, I haven't followed the questions in the chat, so maybe I'll get to that last. Chair, you've raised whether there's a board that will perform oversight of the tribunal members. There is no board. The tribunal will be overseen by the minister. They ultimately report to the minister. So if there are any issues affecting the tribunal, it will be the minister that would be responsible for that. The qualities of members, yes, legal is important, but it's not the only skill that we're looking for. And I think it's important to stress that because I think a tribunal of this nature will benefit from an array of skills from different members. And that's why the Act says that in addition to the chairperson who must be a legal expert, we're also looking for individuals with other relevant experience, be that in consumer advocacy, industry, commerce, or business. So ideally, the 4 members that we would have would be the chairperson with legal expertise, and then the 3 others with an array of skills, either in the business environment, in the consumer advocacy environment, or any other industry that would be beneficial to the functioning of the tribunal. So I'm definitely not in favor of a tribunal that is lopsided with legal support. I think it's important that we have legal support and legal expertise, but more important is to have the right skills mix from the other 3 members. So that would lead to a strong tribunal that is under the chairpersonship of somebody with legal expertise, but the 3 other members will have that industry, commerce, consumer advocacy experience, and that would make a really good functioning tribunal. Then your last question was on the ranking of members. I'm not too sure. When I spoke to the procedural officer, it was mentioned that we would have a scoring sheet. So my understanding is we will rank each nominee in terms of how they perform. And what we could then decide on is if the committee feels that we will have 4 members, that will be your tribunal, and then 4 alternative members. So perhaps what could be done is to rank in the legal expertise area, your first candidate and then your second candidate, and then you do the same for the ordinary members. Your first candidate that you feel should be part of the tribunal members, and then the second candidate would be a nominee for the alternate member on the tribunal. So in essence, the recommendation could be that we have 4 members that we advance, and then an additional 4 members that are advanced as alternates to the first choices. So all 8 will be appointed, but the second level will be alternate members, which means that they will only participate if one of the original appointees are unavailable for a particular matter, or resigns or withdraws, and they could then step into that space. I just need to check the chat quickly for Member Nkondlo's questions. If a tribunal was not operational for these many years, what happened and how were consumer investigations attended to? So remember, with there being no tribunal, we've continued to function based on our alternative dispute resolution function. So we've continued to assist citizens by trying to resolve those disputes between them and the business, and we've been very successful in that regards. So in those matters, we've been able to resolve those disputes. In matters that were unresolved and which would have been referred to a tribunal if it was in existence, what we then had to do, we referred those matters to the National Consumer Commission, who then investigated those matters and advanced, in some instances, those matters at the National Consumer Tribunal. So that was the only avenue that we had available with the lack of the tribunal, was to send those matters to the National Consumer Commission for them to advance a prosecution at the National Consumer Tribunal. Not ideal, as I've said in my presentation, but that was the situation that we faced, and that was the way that we had to deal with those specific issues. The second question: how is the alignment done between national and provincial legislations, and which takes precedence? Very important question that you've noted. So one of the processes that we currently undertaking, member, is a revision of our Western Cape Consumer Affairs Act, because currently it is not 100% aligned with the Consumer Protection Act. So we are currently undergoing a process of alignment with the intention that the revised piece of legislation that we want to introduce is a mirror of, well, not necessarily a mirror, but it speaks to the Consumer Protection Act on a national level, so that there is no inconsistencies or misinterpretations between the national legislation and the provincial legislation. If there is not a misinterpretation, there's a contradiction between national and provincial legislation, the Constitution provides the framework as to how which piece of legislation takes precedence, and in 99% of the matters, it will be the national legislation that takes precedence. In the consumer protection environment, one of the reasons why the National Act was introduced was to set national norms and standards. And if you refer to the Constitution, that is one of the criteria that is listed when you're dealing with a contradiction and deciding which piece of legislation dominates the other or takes precedence of the other. If one of the criteria is that it sets national norms and standards, then that can be utilized as the guiding framework for deciding that the national piece of legislation would take precedence. What's the rationale of skills collaboration with NYDA? That seemed not to be about consumer affairs, but general skills development. The NYDA, in fact, approached us, member, and specifically from a consumer affairs perspective, because as I indicated, they've identified that particular program as one where they want to capacitate possible parolees or release prisoners with the ability to start their own businesses. And why they've looked for our involvement is to speak specifically to the consumer protection angle. So to capacitate a potential business operator with understanding what are the rules of the game within the consumer protection environment, because every business that operates will have an obligation to comply with the consumer protection legislation. So hence they've roped us in from that perspective to speak to the attendees about what are the rules and regulations with regards to consumer affairs matters when it comes to operating a business. And as the project unfolded, the NYDA also saw that we do a little bit of work on basic financial literacy. So also capacitating the attendees on how do you manage your money? Why is it important to put up a budget when you start in a business? What are the things that must go into that budget? And all of the other issues that connects with that. So that was the collaboration between the NYDA and our office on that particular program. Your last question, what mechanisms are in place to mitigate political and business interests and influence capture over the tribunal? My response to that, member, would be that the legislation specifically provides that if there are any conflicts of interest, a tribunal member is obligated to list that and recuse themselves from operations. I'm also, I'm confident that the process that we will be going through as a selection committee, interrogating the skills and expertise and competence of nominees, will also enable us as a committee to ensure that there are no political or business interests that eventually or that could become an issue within the tribunal. It is always a possibility once a tribunal is established that certain issues might come into play, and the oversight responsibility of the minister, I suppose, would also kick in that regard to ensure that those issues are mitigated, as well as the department's responsibility. We'd be, to an extent, managing the functioning of the tribunal, and it will be our ethical and moral responsibility that if we determine that there might be issues such as that coming to the fore, that we as a department will take the necessary action to ensure that the tribunal remains one that is impartial and not influenced either by business interests or any other interest that might be at play. I hope that I've managed to answer your questions. If there's a follow-up, I'll try my best to answer that. Thank you, Chair.
Thank you very much. I will now open up to any further questions, members. I recognize Member van der Westhuizen. I'd just like to note, Mr. Sil, that Member Nkondlo has lost internet connection. She asks if you could please email her in writing the responses that you provided. She's struggling with load shedding. So I'll recognize firstly Member van der Westhuizen, then Member Brinkhuis.
Yes, thank you, Chair. And it wasn't part of Mr. Sil's response, but I do note with interest the fact that under Section 16, any person who, for example, was an office bearer or an employee of any party or movement of political nature may not be appointed to the tribunal. So hopefully that will also address at least one aspect of Honourable Nkondlo's concerns. Just again, back to the interview process, the application process, etc. I would like to see the best qualified people to be appointed to the tribunal. Now, best qualified, I know it's open for debate, but may I just ask, would anyone whose name appear on the, can I call it the chairperson's list, be eligible for appointment under the list of other members? And if not, why not? Secondly, I do believe that it might also have an effect on those that avail themselves for the tribunal, whether they would need to travel to Cape Town physically for sittings, or whether they would be able to take part in the majority of these cases virtually. So is there any clarity? I think when the legislation was drawn and it was envisaged that people would perhaps have, well, as a province, we may have more than one tribunal to cover geographic spread. I think since then, a lot of things have changed, as Mr. Sil has indicated, so also in terms of the training. But my question is specifically in terms of sittings. And when people do need to physically attend meetings or sittings, what infrastructure would be used by the tribunal? Where would that be? We generally assume that this will be in Cape Town CBD, which may also impact on an applicant's decision whether he or she wants to go ahead with his or her application. Those are my three questions for this round. Thank you, Chair.
Thank you very much, Member. I recognize Member Brinkhuis. His hand was up.
Thank you very much, Chair. Good morning to everybody again. Chair, yes, Mr. Scholz, that can I get an indication of the marketing budget for this office, the Consumer Protector's office? How much money is budgeted for marketing? Thank you, Chair.
Thank you very much. I just had a follow-up question with regards to the scoring. So I just wanted to clarify, does the panel recommend one candidate for the chairperson position and then another for the alternate? And then For the next 3 members for the tribunal, do we then recommend them as well as an additional 3 alternates? I just want to make sure I'm understanding that 100% correctly. Then I just had another question. Member Brinkes reminded me when he asked about marketing. So is it possible to find out, noting that you got quite a good number of applicants for this round, from those applicants, how they found out about this vacancy? And I say this because I see that you advertised in Cape Times, but I know that Cape Times doesn't have a very big reader base. So I think it would be helpful for future to know where people are accessing this information, so that maybe we can be a bit more concentrated in those areas rather than using others that might not be as effective. And I think I had another question, but it seems to have slipped my mind. So for now, I'll hand back to Mr. Saul.
Thank you, Chairperson.
May I link
Apologies.
onto the question regarding alternates? Because
Yes, please
I
proceed.
have one in my next round. I'm just thinking that perhaps if the chairperson is absent, one of the other members that are a regular member, if I may call it like that, may perhaps be in a stronger position to lead a meeting of the tribunal than an alternate chair that may not have been involved in the affairs of the tribunal at all. And I do hope that that also link onto my question whether somebody with a legal background might be included under the list of other members. I just, ask myself, if I've never been involved with the Consumer Tribunal, out of the blue, I get a phone call and say, the chairperson can't attend tomorrow. Please, you're an alternate. Please step in. You must chair this tribunal's meeting, whether that would be the best scenario possible. Thank you.
Thank you. And I just remembered my last question before I hand back to you, Mr. Sill. My question was with regards to conflict of interest, whether there is a conflict of interest, whether an applicant is currently a member of the gambling board or, for example, the Liquor Authority in the Western Cape, noting that these entities are in place to protect the business rather than the consumer, and if that might generate a conflict of interest. All right, I'll hand back to you now. Thank you.
Thank you, Chairperson. Let me just refer to my notes. So can a chairperson nominee also be appointed as an ordinary member? In my view, I don't see any impediment to that. I think it can be done, provided that the individual nominee can be classified as, in addition to the legal qualifications, also having certain expertise in those 3 areas which the Act mentions: industry expertise, commerce or business. And many of the nominees that I've seen actually do fall in that category. So besides them being an attorney or an admitted advocate, the nature of their work has exposed them to commercial business, has exposed them to consumer advocacy, and has exposed them to other business-related matters that are relevant to the functioning of the tribunal. We also have one individual who qualifies both as a legal expert because she's a professor of law, but is also an academic. And that for me qualifies both as a legal expert, but also as an expert with industry expertise, for example. So in my view, Member van der Westhuizen, I don't see any impediment that would prevent some of the nominees in the chairperson category from actually being considered for nomination as a member in the ordinary member category. In fact, we did that when the tribunal was originally appointed. We had Advocate Robbie Vincent as chairperson, and Advocate Mdludlu was appointed as an ordinary member because he had expertise in industry, business, and consumer advocacy. So he dovetailed between the two. So definitely, I don't see any impediment there. Also, just to go back to Member Nkondlo's question regarding, influence and that type of issue. I omitted to mention that besides what the legislation prescribes, and there is a particular provision that says that if you're a member of a political party, that kind of excludes you. But in addition to that, we must note that we've done a comprehensive probity exercise. And the probity exercise has also looked into your membership to structures and your appointment to boards, etc. And my colleagues from the service provider will go into detail with regards to that. And where they have seen that there's a potential conflict of interest, they flag that. And that kind of dovetails, Chair, with I think it was your last question, where you mentioned that, some of the nominees might be current members of the gambling board or the liquor authority. And, depending on the structure, depending on the nature of the function that they perform. So if, for example, in the gambling industry, would somebody who is the chairperson of that committee, would that possibly render that as a conflict of interest? I don't necessarily think so. One would need to look at, the functioning of that particular institution that they serve on and evaluate whether there is a potential conflict of interest. But just off the top of my head, as I'm sitting here at this particular point in time, I don't necessarily think that there would be a conflict of interest, from such an individual. The concern that I would have for such a nominee is just availability and availability of time and the demands, although as we've indicated it might not be a full schedule of disputed matters that we'd be advancing, but the tribunal will be functioning and there will be expectations on the members. So my concern with somebody that's sitting on a multitude of boards and institutions would be the availability and the ability to serve the function effectively. So that would be my concern with those types of individuals. Just in terms of the possibility of hearings being held in not other provinces, in other areas within the Western Cape. Yes, most definitely it is an issue that we've considered. And what resources or what infrastructure would be available to us if we, for example, need to use or have a hearing in the Beaufort West area. So what we've done is the equipment that we've procured for our space is possible to be utilized anywhere across the province. In terms of venues, etc., our strong relationships with other departments in the provincial government sphere, the national government sphere, and even on the local government sphere, we've already had interactions with some of these structures to ask that if we, for example, need to conduct a hearing in Plettenberg Bay, is there a possibility for us to use your resources? And we've got positive feedback, from those institutions. So we're hoping that it will be done in that way. And then just in terms of travel, if we have a matter outside of the city that needs to be adjudicated, we want to be or the tribunal needs to be one that is responsive to the needs of the citizens and businesses. So within our operational budget, we will need to, we've in fact included possible expenditure with that regard for the tribunal. So we have taken cognizance of that. So within our own operational expenditure budget, we've allocated some resources for matters where the tribunal would need to travel. The last thing we would want to do is to inconvenience a business or a citizen to come from Beaufort West all the way to the Western to Cape Town for a hearing. We want to be responsive, so we've factored that into our operations, and we're hoping that as we move forward, as I've said, and maybe the members can assist us in that regard. We'll be lobbying for a greater budget for the tribunal to assist us to, in fact, roll out these services far more comprehensively. In terms of the marketing budget, member, for the upcoming financial year, we will have a 700,000 Rand budget for marketing and education. It's not a tremendously voluminous budget, but it's a budget that we have available to utilize not only for the services of the tribunal. It's a marketing budget for the office in totality, for all the services that we have. But we've become very adept at, because we usually receive a smaller budget, we've become very adept at engaging with stakeholders within the media area. So whether it's community radio stations where we get free airtime, and other platforms as well. So in addition to that small 700,000, there's also other avenues that we usually explore. And we've also engaged with the National Consumer Commission with regards to communication campaign and marketing with regards to the services of tribunals, consumer tribunals in general, not only in the Western Cape, but those in the other provinces as well. So yes, it's a small budget, but we try and squeeze every bit out of it that we can, and we try and leverage resources from other entities. Chairperson, the question of alternates, my suggestion would be yes, that we would have let's call it the main nominee, and then an alternate, not only for the chairperson, but for each we've got to appoint 4 people for the main tribunal. So I would say for the 3 other ordinary members, it would, in my view, make sense that we do the same there, that we recommend 1 person and then an alternate as well for that particular position. So we would have 2 people for each area. If I hope I'm making sense with regards to that. I think your suggestion with regards to inquiring from the nominees as to where they heard about the nomination process makes complete sense. It would assist us in future, because I also have the concern that we often use a particular publication, and maybe that's not the most ideal publication that is utilized. And if you look at the cost that comes along with those publications, a little bit of research that can be done, and it's possibly something that we could ask. For this round, we can inquire from the candidates, but we could also look at maybe inquiring from our own research unit to do some work with regards to that. It will assist in as we go along, because it might just be that most of these nominees actually heard it word of mouth, and that our radio broadcast process and our face-to-face engagements has been more successful than the actual print media campaign. So definitely I take that issue on board. I hope I've answered everything. If I failed to address any question, please alert me to that, members.
I think you've covered everything. Members, I'll give you one last opportunity for any burning questions, and then I'd like for us to proceed. Member van der Westhuizen, your last burning question.
Thank you, Chair. Chair, I'm still concerned about the uncertainty in my mind for the demands that will be made on the people that will fill positions on the Consumer Tribunal. We've seen other tribunals in the Western Cape building up huge backlogs of cases. And, I believe that this may be one of those cases where your success may eventually also be the factor that unfortunately, negatively impact on you. If we only have a budget for 2 sessions per month and people start getting huge success in resolving cases through the Consumer Tribunal, I can just imagine that the caseload might increase tremendously. So again, what is the experience in our other provinces? Are there no backlogs for them getting by with only 2 sessions per month? And if I may, Chair, just to understand the requirements also that we're going to put to the selection criteria, how does this differ from the small claims court? And for example, the limits on the small claims court, the backlog or the caseload there, is there a danger of overlapping? Is there a danger of the one venturing onto the field of the others? Thank you.
Thank you very much. So that will be the last question for this round. I'll hand over to Mr. Sil, and then from there we'll move on to the next part of our program.
Thank you, Member van der Westhuizen. And I think, you raise a real concern and possibility. So we could be the victims of our own success. If the tribunal functions effectively, we've got a great communication platform, and people suddenly see, that this is the better option, in comparison to either the small claims court or the civil courts. We could find ourselves in a situation where we suddenly have a huge influx of matters that comes through to us. I will answer your question by looking at the history when we had the tribunal. We did not have that deluge of matters coming through, because there's a step before the tribunal, and that is the alternative dispute resolution process, where we've seen, let's say, our numbers increase in terms of the complaints coming through. At least 60% of those matters, member, would be resolved by the alternative dispute resolution team. So the fact that our numbers would maybe shoot up, let's say by instead of getting 1,000 complaints in a year, we now get 4,000 complaints, which was a real scenario pre-COVID. Even with those vast numbers, we were able to resolve approximately 60% of those matters through alternative dispute resolution processes. And the limited matters that were unresolved, either there were no prospects of success in a particular dispute, because not all disputes that comes through to us are have merit to them. The citizen might feel that it has merit, but when we consider the facts and the legislation, it often transpires that there is no merit to a particular matter. So although a possible eventuality, based on past experience and also based on an evaluation of what's happening in the other provinces, especially the ones that started to initiate a tribunal service. The first year or 2 years didn't suddenly see a backlog being built up. The one institution that does have a backlog, undoubtedly, and that's the National Consumer Tribunal, because many of the matters that the National Consumer Tribunal is dealing with are matters that are not province specific. So it is disputes which affects each and every province, and it's systemic systemic issues in the dispute arena, in the complaint. So it's a complaint that will have universal impact on consumers across the country, and their caseload is quite heavy because they're taking on those specific matters. And the other provinces are not experiencing a hectic backlog. So yes, it is anything is possible, but for the first year or so, I'm not anticipating a huge backlog being built up, because as I'm saying, we will have the alternative dispute resolution process that will precede the tribunal, and we're hoping that the majority of matters that comes through our doors will be resolved in that fashion. So I'm hoping that I'm to an extent allaying some of your fears, but having said that, anything is possible. It could be an eventuality. If it does arise, then we would need to take stock of how we address that. And there's mechanisms that we've already started thinking about in terms of how to address that if the eventuality does materialize. Will this process dovetail or impact on the small claims court? Consumers ultimately have, in terms of the legislation, a choice in terms of how they want to have the matter adjudicated. The small claims court process will remain there with its limitations. Obviously, there's there's a jurisdictional limit in terms of the amount, that a small claims court can intervene on. So I'm not suddenly seeing the small claims court process taking a backseat or stop becoming utilized by citizens. I think that will continue to remain a viable option for citizens, and we see it in other provinces as well. With the advent of the tribunals in those provinces, it hasn't had a negative impact on the role and function of the small claims court. I think the two processes will work in conjunction with each other. Yeah, I hope I've answered the questions. And as I've said, I acknowledge what member van der Westhuizen has said, but I'm hoping that my response has allayed these fears a little bit, based on the historical functioning and based on what's happening in other provinces at this particular point in time. Thank you.
Thank you very much, Mr. Sil. Members, if there are any further questions, if I could ask that you please send those through to us as resolutions, and then we can submit those through to clarify them. But for the sake of time, I do think we need to quite swiftly move on. So the next portion of our program deals with the briefing by Moa SA Forensic Services on the probity outcomes, or the probity outcomes rather. Members, I'd like to put it to you before we proceed on whether or not this portion of the meeting that focuses on the results of the probity should be closed. My proposal, members, is that it does be closed, since the probity reports are considered confidential and contain a lot of very personal and sensitive information about the candidates. So members, I'll put this to you, but I just also like to note that in terms of Standing Rule 72, it does allow for a meeting or a portion of the meeting to be held in camera, closed to the public, if there is a reasonable and justifiable cause for the meeting to be closed, in which case, of course, we'd want to protect the sensitive information that was shared through the probity outcomes while we analyze this way forward. With that, I recognize Member van der Westhuizen.
Thank you, Chair. I would like to submit a motion that this meeting will henceforth be a closed session until decided otherwise. Thank you.
Thank you very much. Members, is there a seconder?
Seconded, Chair. Thank you very much.
Thank you very much. Then I would just like to call on Ms. Adams. Ms. Adams, if you could please assist us in terms